Hello and good morning, everybody. Welcome to this morning's webinar. Just getting sorted here. Hope you can all hear me. This morning we're looking at all things new in employment law for 2019. My name's Laura Murphy and today I'm joined by my colleague Nicola Sheridan.
Good morning, everybody.
Just a little bit of housekeeping before we get started. As always, we'll have our Q&A session at the end, so please type in your questions as you think of them and as they pop into your head, but we will come to them at the end if you don't mind. And as always as well, we are recording today's session, so we will send a recording and a copy of the slides to everybody later on after the webinar as well. Just look at our agenda quickly. As you can see, it's a fairly busy agenda today. These employment law updates always are, and particularly this year seems to have a lot of updates going on.
Yes, indeed.
We'll look at the Employment Act that was introduced earlier in the year. We'll then look at some changes to parental leave. So we'll look at the new sectoral employment orders. We'll look at legislation surrounding employee tips and gratuities, gender pay reporting. We'll have a quick look at what the WRC have been up to of late, and we'll look at some recent cases. Throughout the webinar, we'll try and show you some of the solutions that Thesaurus has in place to help you deal with these employment changes where possible. And as I said, we'll have our Q&A session at the end. So to start off, we'll get going with the Employment Miscellaneous Provisions Act 2018, which came into force back in Ireland back in April of this year. At the time, we had a lot of in-depth webinars and we went into a lot of information about what the Act entailed. We're not going to go into that much information today, but I just want to give you an overview of some of the key provisions of that Act, just so you can remind yourself of them.
Yeah, so perfect. So firstly, we're just going to have a quick look at the terms of employment. So employers are now required to give their employees a basic contract within 5 days of starting employment. And within that, there are 5 core terms that must be given, and we set them out here for you. So as you can see, they are the employer and employee's full names, the employer's address. If it's a temporary contract, you must state on this the expected duration of the contract or the date of expiry of a fixed term contract, the rate of method of calculating pay and the pay reference period, and what the employer reasonably expects to be the normal length of the employee's working day and working week. Employers still need to be mindful of the existing legislation that full terms and conditions of employment must still be given in writing to an employee within 2 months. So understandably, some employers might be feeling that they now have an extra amount of work to do. So to avoid duplication of work, I suppose employers are well advised to provide a full contract of employment in advance of starting employment, therefore reducing the risk of breaching the legislation. So just for your information only, we've included the 15 terms that need to be provided to employees. We're not going to go into detail on these now, you can just see what they are, and this will be part of the slides when you receive them after the webinar. If you are reviewing your existing contracts, so just to make sure you're being compliant, you can tick off your current terms and conditions against those listed here.
Absolutely, and just to say, this is the statutory minimum that should be in your contract. It's highly likely that any kind of robust or strong contract is going to have additional terms above and beyond this, taking into account different roles employees have and different arrangements in different companies.
Absolutely, yeah. And I suppose on to the interesting or possibly scary piece of the legislation when it came out is, of course, the fines and possible imprisonment for failure to provide the necessary documentation. So just to be very aware of that. As a nice little incentive to ensure you remain or possibly become compliant.
Absolutely. We haven't had any imprisonments yet. I don't think the intention is to fill Mountjoy with HR practitioners, but it's certainly to act as a deterrent, so it is there and it is
to make it. Yeah, that's
it. So just move on to the second point that we wanted to highlight from the Employment Act. So the Act amended the Organisation of Working Time Act to prohibit 0-hour contracts. So an employer is now no longer permitted to engage an employee on a contract on an as and when basis or where the stated hours in the contract are 0. They can only do this if it's a genuine casual work situation or an emergency situation to give you some relief work. Just one other point around the whole casual working, there is also a new minimum payment that was introduced with the Act, where an employee is required, sorry, I'll start that one again. Where an employee is required to be available for work, but he or she is not provided with the work, they are entitled to a payment of either 25% of their contracted hours or 15 hours, so whichever is less. In either case, the minimum payment which the employee must receive must be 3 times the national minimum wage, which is currently €9.80. So the minimum payment that an employee must receive would be $29.40. If they're contracted for so many hours and you called them in, but then you sent them home because you didn't have the work available, these are the hours this is the payment that they must receive. Just to move on to the third point there in relation to banded hours, which is a new concept brought in again by the legislation. Employees whose contracts do not accurately reflect the reality of what they are working can now request to be placed in a band of hours that better reflects their average working week. In order for an employee to put through such a request, they must have been working for a reference period of 12 months. And once you as an employer received a request for banded hours, you have 1 month to reply. And we've set down here in the legislation what those 8 bands are. I suppose when deciding which band to place an employee on, if it was brought to you, I suppose, it's just an average of the number of weekly hours that an employee has been working over that reference period of 12 months.
Yeah, and sorry, Laura, just to cut in there. So we do get a lot of questions on this. So I think it's worth just reiterating that you only have to issue a banded contract in response to an employee's request. So if there's no request, there's no action required by you.
Absolutely, yeah. So we do get employers saying, do I have a new employee starting? Do I have to create a banded hours? No, only if an employee requests.
If they request.
And actually, if they do request it, you can refuse it. There are reasons or there are grounds where you can refuse a request. And I've listed them here. If there's no evidence to support the employee's claim, if there have been changes in the business, emergency situations, or if the average hours worked were affected purely by a temporary situation. If an employee was unhappy with your result, or if you had refused it and the employee was unhappy with that, they could go and bring a complaint to the WRC, who in turn then, on review of the situation may issue a decision whereby the employee must be put on a banded hours. And again, this is all exceptional cases, but it's only a decision in this case that the WRC would give. They wouldn't ever award compensation in this kind of situation.
Okay, so moving on then to anti-penalisation. So it is also an offence now to penalise an employee in any way for exercising their rights under the Act. So penalisation covers a detriment to terms and conditions of employment, so discipline or dismissal, transfers, changing hours, reducing pay, and intimidation. If an employee is found to have been penalised as a result of exercising their rights, they can be awarded compensation of up to 4 weeks remuneration. So a big cost then to the employer if they partake in that type of behaviour.
Absolutely.
And finally then, just one very quick point, there's a small change to the National Minimum Wage Act. The change to the Act applies to workers under the age of 19. So previously, minimum wage for those under 19 was calculated based on their experience and how many years they had worked. Now it's simply calculated as a percentage of minimum wage, and I can see the different values there in the table.
Yeah, and just to say actually there, Nicola, as well, we are expecting a further increase to the minimum wage come January 2020. And we have a 30-cent increase coming up. So minimum wage is going to go through that €10 barrier. So these these rates here will change come January
then,
to be in line with the 70, 80 or 90%.
Yeah.
Perfect. So I suppose just before we finish off on the Employment Act, just a few top tips, I suppose, to help you ensure compliance with the legislation and stay out of trouble. So if you haven't already done so, be sure that you review your current contracts of employment. Make sure that you're including those 5 initial core terms and then the 15 terms that Nicola spoke about as well. Ensure that you're providing them within the correct time frames as well. Have you got systems in place that you can have contracts ready within the first 5 days, just to prevent any kind of, make it as easy as possible for everybody. Be sure that you review all your employees' hours. Just check, does the contract that your employees have, does it accurately reflect what they are actually working? And it may be a case that you might want to just take it upon yourself to update the contracts. And then if you do have any situations where you have people work, you may have people working on 0-hour contracts, you might want to look to address that.
Yeah, stop that. So as we, have discussed here in detail, employment contracts are hugely important to every business. And here at Thesaurus, we are helping our customers meet their employment requirements through our Bright Contracts package. This allows for simple and inexpensive employment contract and staff handbook generation. So it's essential here, and you can tick off all the required terms in one simple go.
Yeah, absolutely. And what we'll talk about later as well, I'm flying past there, sorry, is that we keep it all up to date as well. Perfect. So we'll move on to parental leave.
So parental leave is our next item on the agenda, and this is something that has happened. So in an effort to develop supports that are currently in place for working parents, the government is proactively working on a range of changes to existing parental leave.
So before we get into the legislation, it was just when we were doing the research for this, bit of an article that I had come across of a survey that was carried out by Expert Market, and they had surveyed 37 countries, and of the 37 countries, Ireland came in as the eighth worst country to work if you're a parent. So plenty of room for improvement. So hopefully this new legislation will help that.
Absolutely. I think that's the intention as well, Laura. So I suppose what the Act now means is that since the 1st of September just gone, some important changes to parental leave have come into existence. So prior to the 1st of September, parents were entitled to 18 weeks parental leave, which had to be taken by the child's 8th birthday. Under the amended legislation now, employees are entitled to 22 weeks parental leave, so an additional 4 weeks leave has been given, and they have until the child turns 12 to take that leave. Again, now from the 1st of September 2020, this entitlement will increase by a further 4 weeks to 26 weeks. And just to note, there is an extension where the child is disabled or has a long-term illness.
We just have a bit of an example there for you.
Yeah, so we'll look at a real life example now of how this works in practice. So we'll take John and his beautiful daughter Jane. Jane is 9, and before Jane turned 8, John only used 10 weeks of his 18 weeks parental leave that was available to him at the time. His unused 8 weeks then expired when Jane turned 8, and John unfortunately then was not able to take that leave. Now, with the changes, since the 1st of September 2019, John is entitled to an additional 4 weeks parental leave, plus the 8 weeks previously unused are now going to be restored, giving him a total of 12 weeks remaining that he can use to spend some quality time with Jane. And he has also until Jane is 12 now to use this entitlement. Just note again, from the 1st of September 2020, John is going to be given a further 4 weeks of parental leave, and again, he must use that before Jane turns 12 or it'll be lost.
Perfect. I want to just move on to look at an employee's entitlement to parental leave. When can an employee take parental leave? So generally an employee must have been working with you or with the employer for 1 year in order to take it. And parental leave is available to whoever is in the role of the relevant parent. So it can be an adoptive parent or an individual acting in loco parentis. It's also important to say that parental leave and the 18 weeks that Nicola just spoke about is available to both parents. It's not per child. So in the traditional family, it's available to both the mother and the father would have their own 18-week entitlement.
And then just to say, if both parents happen to work in the same company, an employer may agree to one parent transferring up to 14 weeks of their own leave to the other parent. There's no transferability of leave between employees if they have different employers.
Different employers, absolutely.
Yeah.
So then in terms of the employee giving you notice, the employee needs to give you 6 weeks notice of their intention to take parental leave. An employee who is on parental leave, their annual leave entitlement is not impacted. All their main terms and conditions of employment remain the same, except their pay. If the employee has more than one child, parental leave is limited to 18 weeks in a 12-month period. However, this is at the discretion of you or the employer. If you agree to more, then that's allowed. And then also, if an employee is working part-time, then their parental leave entitlement is reduced on a pro rata basis.
Yeah.
So then just to move on to consider you as the employer. Now you've received your request from the employee to take parental leave. how do you manage that, I suppose? So first, to say that you cannot refuse a request for parental leave. It's a statutory right, the same as taking maternity leave is a statutory right. You may, however, postpone an employee's request for a period of up to 6 months. So you might postpone if it's a particularly busy period in your work, in your office, whatever it is, a seasonal busyness, I suppose. So you may be allowed to postpone there. If you do want to postpone, you have to, again, give the employee 4 weeks notice. And really, it's only ideal to postpone once. Beyond one period of postponement, you would have to have exceptional circumstances. Record keeping, and we'll talk about record keeping later on and the importance of record keeping, but just to say here, all your paperwork in relation to parental leave, you need to keep your paper records for 12 years, and that's in line with the duration of how long the parental leave is available to the employee that Nicola spoke about. The legislation then, the permitted format. The legislation sets out minimum periods which the leave can be taken. So for example, leave can be taken in one continuous block, so one block of 18 weeks, and then it also says in blocks of at least 6 weeks, and we've put that there. However, employers can, at their discretion, be a little bit more flexible and offer some more different flexible arrangements if they can. And we feel where possible, there can be huge benefits in offering that flexibility in terms of being able to attract top talent, staff retention, reduced staff turnover. Your staff are able to better manage their time, be it their work life and their home life. In turn, then that leads to improved employee well-being and improved morale and employee engagement in the workforce. So definitely there's benefits of being able to offer parental leave. And whether you offer that as 1 day a week, job sharing, 2 days a week, 3 days a week, there's different ways that you might consider, and it'll all depend on your own business and your own organization. But I'd certainly recommend that if you could think about it,
just the benefits to both the employer and the employee have been proved as well. So it's definitely worth considering.
Absolutely. And I suppose in this current climate of almost full employment, where it can be difficult to attract and retain staff, offering flexibility is definitely the buzzword at the moment in terms of attracting staff. So it's worth considering.
It sets you apart then from other employers as well.
Absolutely.
Currently, as we said, parental leave is unpaid, and it remains to be seen whether this increase in entitlement will actually result in an increase in uptake, which has to date been low, presumably because the leave is, again, as we said, unpaid. However, the government has a new parental leave scheme, and within this it includes an intention to have 7 weeks paid parental leave per parent by 2021. As part of this scheme, a bill is currently being drafted that will introduce 2 weeks paid parental leave during the first 12 months of a baby's life. It's expected this bill will take effect from November this year, and the leave is in addition to the current paid maternity and paternity leave. So slightly different entitlement criteria will apply, including the fact that the paid parental leave will only be available in the baby's first year of life. So in the case of multiple births, only one period of leave will be available to each parent. It's intended the Department of Employment Affairs and Social Protection will pay the parental benefit at the same rate as maternity and paternity benefit, and that is currently set at €245 per week. So it will be totally at the discretion of you as employers if you wish to top up the payment to salary level or not.
Perfect.
So before we finish up on parental leave, a few top tips very briefly. So company policies should be reviewed and updated to reflect the changes being introduced. This is going to help you prepare for any increase in staff requests that you may get. Make sure you have your paperwork and your record keeping in order. Again, always very important. Considering the benefits that Laura has just gone through, you might look at whether your business could offer any alternative flexing working arrangements to the benefit of your staff. And then come November, if parental leave is introduced, you need to decide on whether or not you'll be able to top it up.
Parental pay.
Oh, parental pay, sorry.
Now, in my experience, it's unlikely that many small companies will top up parental pay, going from experiences with paternity pay and maternity pay. However, I have come across companies that do top it up. but I've also come across companies who've got themselves in a little hot water around the situation, because they might top it up for one person and then they decide, oh, they're not so sure about another employee, so they won't bother topping it up for them. And that inconsistency is where employers are going to get themselves in trouble. Yes. So whatever action you do take, our advice would just be to be consistent and have a good policy in place, and have it down in black and white and have it in writing.
Yeah, and employees do talk to each other as well. So
absolutely, yeah.
Just to bear that in mind.
Yeah. And just then,
so of course our Bright contracts. So the package, the update to the software has already been released in the parental leave policy in the staff handbook section. So if you're a customer, you will have seen the update about this when you open the software. So you can take comfort from the fact that all the work has already been done for you, and the changes are now live within your staff handbook.
They're ready to go.
They're ready to go. Yeah.
Brilliant. Okay, well, we'll move on from parental leave. I see there are some questions coming in, but we'll get to them again, as I said, at the end. That's great to see them coming in. I just want to touch on the SEOs, the Sectoral Employment Order. Now, this is not going to apply to everybody, so we'll just go through it really, really briefly. This year, we've had 2 new SEOs. On the 1st of September, just gone, we had a new SEO in the electrical contracting sector, and that's going to be followed on the 1st of October with a new SEO applying to the construction sector. And just to clarify, an SEO is an order that applies employment rights above and beyond statutory minimum. So it'll be a minimum wage that's above statutory minimum wage. And we'll go through the details here now. Again, just really briefly, I've set out the minimum wage rates for the electrical contractors. Other aspects of their legislation or of the SEO includes a normal working week times, and then overtime payments beyond that, a particular pension scheme, death in service, sick pay, and a particular procedure in relation to disputes. In the construction sector, it is again very similar. In terms of the rates of pay are different, but in terms of the other aspects, the pension scheme, the disputes resolution procedure, that's similar as well. Just to say that for anybody in the electrical contracting and anybody in the construction sector, these are mandatory terms. It's not optional. So even if you are not a member of the Construction Federation of Ireland, this SEO is still going to apply to you. So if we do have any of those people attending today, just a few quick notes on what our top tips are in terms of what you need to do. You need to review your contracts of employment. The Terms of Employment Act specifically provides that the employer must notify employees of the existence of an SEO. So your contracts have to specify that the SEO is in place and the contract is in line with the SEO. So be sure to review your contracts. That's really key. And then finally, just to review your pay rates and to review all your other policies and procedures, just to be sure that they're matching up as well.
And again, Laura, just to help employers with that, our Bright Contract software has functionality to help employers ensure that any employment contracts they issue are compliant with SEO industry standards.
Absolutely, and actually when doing this slide, Nicola's just highlighted the little brown snippet here, and they're throughout the software and they're really useful just by clicking on them, and they pop up greater information and links,
additional information
to help you complete your contracts.
Yeah.
So we'll keep moving along, and I just want to talk about the employee tips and gratuities. This is in the pipeline. It hasn't happened yet, so it's coming.
Yeah.
And the Minister for Employment Affairs and Social Protection, Regina Doherty, she's received approval from the government to proceed with this legislation. So it's in draft stage at the moment. And the aim of it is to regulate how employers treat tips and gratuities. It's in response to a number of recent claims or suggestions that some employers may have been using tips to satisfy employees' contractual pay rates. I suppose the current legislation around this is that tips cannot be used to satisfy minimum wage rates, but beyond that, the law doesn't state anywhere that there's nothing to prevent an employer from using tips to pay salary above minimum wage. So I suppose the objective of this new legislation will be to ensure that tips and gratuities cannot be used to make up or satisfy contractual wages, and also there's going to be a requirement that employers in the service industry where this may apply to them will have to make their policies on tips and gratuities visible for both employees and for customers. So it has to be, they'll have to be putting them out there.
A big change. Yeah.
Absolutely. So as I said, it's coming down the pipeline. It's not in yet, and I can't give you a time frame just yet, but definitely for employers who are in the service industry, it'll be something that you'll want to keep an ear to the ground on. But certainly we'll let you know as well as soon as we know more information.
So moving on now to gender pay reporting. In April of this year, the government published the Gender Pay Gap Information Bill 2019. The bill has been presented to the Dáil, where it now awaits second stage. And the aim of the bill is to provide transparency on the gender pay gap in organisations. So I suppose the first question to ask here is, what is the gender pay gap? So this is the gap between what is earned on average by women as opposed to men in an organisation. It is distinctly different to unequal pay for equal work, where men and women are both doing the same job. There's a very clear line on an unequal pay. It is illegal and outlawed by existing equality legislation, namely the Employment Equality Act of '98. The gender pay gap typically indicates that men and women are not equally represented at different levels of the organisation. So to take a very basic example, in some organisations, all top management might be men and all the administrative staff might be women. The new legislation looks to highlight this and address it, so there is less disparity between the roles held and salaries earned by men and women. So as you can see, the current average pay gap across Europe is 16.7%. In Ireland, ours is actually a little bit lower, coming in at 13.9%. So like at almost 14%, Ireland's gender pay gap means that women in full-time employment are working for free for about 1 month every year. And without taking action, it is believed that it could take approximately 170 years to close Ireland's gender pay gap.
Yeah, we're just on that actually, Nicola, before you kind of move on to the next slide. I don't know if anybody else was listening to RT yesterday lunchtime on the radio, because I heard them talking about an interesting OECD report, and that report said that women in Ireland with a third level degree earn 25% less than men in Ireland with a third level degree. So I don't think we should be too excited about this stat. So depending on what stat you're looking at, it's slightly different. So there's plenty of work to be done regardless.
Plenty of work to be done, my God, unfortunately.
So yeah, no, we just want to go on to what actually the legislation, what the legislation entails, I suppose. And under the new legislation, both public and private organisations will have a reporting obligation in relation to their gender pay gap. Now, initially, the obligations will only apply to employers with over 250 employees. However, it is planned that the regulations will be extended to those with over 50 employees over time. So we're probably looking at around 2021 before that happens, and even maybe a little bit beyond that, because the legislation hasn't come in yet. The reports that will have to be submitted, they will have to be submitted to a designated government body. We don't know who that will be yet, but also they'll then also need to be published on the company's own website. And we've listed the exact information that employers will have to publish here.
Yeah, and Laura, what jumped out at me is the level of detail they're actually asking for. Yeah. So it's not going to be something as simple as just running a quick report.
Absolutely. Certainly a level of planning and managing of the project is going to be needed, particularly as an addition to what we've laid out here in these points. Employers will also be obliged to set out the steps that they've taken or they're planning to take to tackle the gender pay gap in their company. So it'll be interesting times ahead. And I suppose we can learn a little bit from the UK. The legislation gender pay reporting came into the UK in 2017. Their first set of reports had to be published in 2018, and then they published more just in March, April time this year. And I suppose with such salacious facts to be had, there was much media attention out there on it. And many companies, I suppose, found themselves on the receiving end of some very negative press. And these companies, they suffered, I suppose, some reputational damage. Although I don't know if Ryanair needed any more reputational damage, but they obviously were one of the top companies in terms of their pay gaps. And also then I suppose you're talking about the other negative impacts here in terms of employee engagement and retention concerns. And there's certainly been some reports out there where companies are reporting a lot more questions for employees, and they want a lot more transparency around pay. But obviously, as you can see here, it hasn't all been doom and gloom. There's been some interesting stats. McDonald's has no pay gap. Same with Primark and Costa Coffee, I think. And then BT was one of very few companies in the UK that had a pay gap in favour of women. But I think for the most part, it was considerably slanted towards the men.
Yeah.
And just to say, I suppose, as we've mentioned, it's a bigger issue than just having to do the reporting, which is going to be a job in itself for some companies. But as you said, the reputational damage that a large pay gap can show for some companies, and then other companies will be using it as a positive thing, and the commitment to diversity and inclusion, and definitely they'll be trying to boast about that in their job and attracting talent.
Absolutely, yeah, be an attractive thing to get new staff to come and work for you then.
Yeah, and there's also the fact as well that in the UK they said there'll be fines for people who don't report, and fines then if you have an action plan to reduce your pay gap but nothing is done, and you don't reduce your pay gap, there could be possible fines there as well. And it'll be interesting to see how we mirror that
what
over here.
What the Irish government decides to do. Yeah,
absolutely. So I suppose top tips for our customers, and knowing our customers as we do, I would imagine that we don't have too many people here today that will be impacted too heavily by the new legislation, particularly not for the foreseeable future anyway. However, that's not to say that you couldn't consider bearing in mind the gender pay gap as you move forward, because I think this whole topic, and we've already talked about parental leave and on a par, so this whole topic is very topical at the moment. So I suppose we've come up with we've come up with a few suggestions as how you might kind of think about gender pay in your company. So obviously recruitment and promotion is the obvious one. If you're having short lists for interview or for promotion, to include multiple women, not just one but multiple, because that's going to increase the opportunities for women. To use structured interviews, so if you have preset interview questions, and every candidate is having the same questions, that's going to give less opportunity for unconscious bias to slip in. And advertise jobs as having flexible working options. So it could be going back to our parental leave discussion. You've had a think and you're like, actually, yeah, we can offer us a little bit of flexibility here. Put that down in your job advert when you're putting it out there, and you might be surprised. You might get a few different candidates that you didn't imagine you might have. Obviously, encourage uptake of parental leave and paternity leave, and encourage flexible working for all employees, both men and women. And then finally, just review your policies. Do your policies reflect what your approach is and what you're thinking? You might start with your equality policy. That's really important to set yourself up as being an employer who's kind of forward thinking in this regard. And also your maternity, your parental and your paternity policies, all those policies, just to review them. Brilliant. So conscious of time, so we want to keep moving. And now we're just going to have a little look at what the WRC have been up to. I'm sure you're all familiar at this stage that the WRC stands for the Workplace Relations Commission, and it's their job to promote compliance within the employment sphere. To look at the industrial landscape, it's busier in the last couple of years. Looking first at the number of complaints that the WRC are dealing with, you can clearly see here that there's been significant increase in the number of employee complaints going to the WRC. And certainly if you've been watching the news over the last few months, you'll be all too familiar with the cases of those that are listed here. And I suppose this activity is indicative of the times that we are living in with almost full employment.
Absolutely. Sure. People today, Laura, have much greater awareness of what their employment rights are, and because jobs are plentiful, people are not afraid to highlight perceived injustices and to have their employment rights enforced.
Absolutely. Actually, I meant to say it earlier, but we had obviously our support line, and our support is for employers, but we had a random request in yesterday from an employee, and we weren't able to help that employee, but that employee was contacting us in relation to a question on banded hours. So it just goes to show that there's that awareness. People are, there's definitely an awareness. And I suppose in line with that, then it means for employers at the moment, there's a risk at the moment that you could have a claim brought against you, or you'll have that disgruntled employee that goes off to the WRC. So I suppose it's for employers to be aware, to be diligent about how you manage your employment matters, and to have all your I's dotted and T's crossed as much as possible.
As much as they can do, yeah.
Just some phone stats there. It's busy on the WRC helpline as well. But we just wanted to move on to the WRC inspections. And again, I've got some stats here for you. As you can see, in 2017, the WRC carried out just under 5,000 workplace inspections, and this increased by a full 1,000 in 2018.
Yeah, so inspections can be scheduled for any number of reasons. In many cases, it will be because they received a complaint from a disgruntled employee. In other cases, it'll be totally random and based maybe on your location or the industry you're working in.
Yeah, we've had customers of ours before who WRC have picked a street and they've gone up Main Street and gone on every business, knocked on every door, and they do call unannounced. And actually, looking at the WRC's program, they did a work program for 2019 where they set out their objectives for the coming year, and they set themselves the target of 5,000 workplace inspections this year, half of which were to be unannounced. And actually, interestingly, in that program, in that report, they specifically mentioned a number of industries that they were going to target, and they were going to target the equine industry, nail bars, fisheries, car washes, and other professional sectors. So the other professional sectors leaves it wide open.
Just to keep everybody on their toes.
Yeah. And then I suppose just a few stats there that we've included, looking at why employers fail inspections. The most common reason why employers fail inspections is because they have insufficient record keeping. And we spoke earlier about the importance of record keeping. And I know Nicola will talk a little bit about that in a moment, and maybe a solution that we have. But I suppose in the past we've done, to go aside a little bit, we've done webinars in the past on what the WRC inspection looks like, but just very briefly, the inspector will maybe knock on your door. They'll want to have an interview with the HR or whoever's in charge of the people side of it. They'll also look to interview with your employees, and you can't stop that. You have to allow your employees to meet with them, and they'll also then look at your records, your employee files, and they have full access and they have full permission to do that. So I suppose the advice is, if you have a WRC inspection, is to cooperate fully, because otherwise it's just going to reflect negatively
back on you. Yeah. So Laura, as you said, we're just looking at ways of keeping your records up to date, and a really nice way of making sure your records are kept up to date is using Connect. So if you're a Thesaurus or BrightPay customer, you'll have a free Connect access license for 2019. If you are using Connect, you will be familiar with the user-friendly backup, and many of our customers are really loving this feature. However, I want to show you some of the other features that will help you with your record keeping, ensuring then your compliance. So first of those is the documents and resource feature. So through Connect, you can send your employees documents such as their employment contract, training documents, even health and safety notices. A record is then kept on their Connect account of when this was viewed or accessed.
Yeah, this is actually a really interesting feature, and we've actually had just the next feature that you're going to bring up there, Nicola, and the log where employers can view if an employee has viewed a document.
Yeah.
And this is a really interesting
activity
feature.
log. Yeah.
Yeah. We've had customers who have been before a WRC adjudicator in an unfortunate case, and they were able to use this log to prove that an employee had access to a particular document and that they'd seen it and reviewed it and had actually gone into it a couple of times. So that helped defend their case.
Helped defend their case, because they could actually concretely prove that the employee was aware of what the policy was. And again, that's managed through the documents and resource feature on Connect. Connect, it's also great for enabling employees to edit their own employee details, ensuring their details are always correct. So if they want to update their home address or contact details, again, they can manage that themselves through Connect. Another great feature here is Annual Leave Manager. So using the self-service app, employees can submit leave requests at the click of a button. And then the employer dashboard then shows the employee's annual leave requests, and you then as the employer can approve or reject these as necessary.
And what you can also do, actually, just showing this slide, this the view edit tab, so you can hit into that tab when you can go in and you can look at an employee's annual leave entitlement, and you can see what leave they've used, what leave they have remaining. Again, it's just helping you ensure compliance with the Working Time Act as well.
So absolutely, Laura, and another useful feature is helping you maintain your required records is the calendar and reporting feature. So both these features let you see at a glance who has taken what leave when. So this is ideal if the WRC again has landed on your doorstep looking for a certain information. Rather than getting in a panic about what's saved and where, you simply log in to Connect to access your records. And that's how what it looks like, different reports available. Yeah.
Brilliant.
Yeah.
Okay, we're 5 minutes left of presentation, then we're going to get to the Q&As, but we wanted to look at the lessons from a couple of recent cases. I just wanted to look at the issue of, can an employee have legal representation at a disciplinary hearing? Employment law circles had great discussions in regard to this question over recent years, really, rather than months, following a string of cases. And I've listed the cases here. You can see there was one involving Irish Rail and another involving a mushroom farm. So that was the point that was raised at these cases, whether an employee, when holding a disciplinary procedure, can an employee bring their solicitor or the local lawyer with them? And the key point that you need to know from these cases is that legal representation need only be permitted in exceptional circumstances. And then they haven't specified what exceptional circumstances are, but they have specified that a sanction of dismissal would not be considered exceptional circumstances. So if you were going through a disciplinary procedure because of underperformance or particular misdemeanors, it'll be fine not to have legal representation. I imagine the exceptional circumstances would be possibly if there was a case that was involving vulnerable adults or maybe children, or something that was going to lead to a more serious criminal conviction. That's when you might consider having legal representation. But in the day-to-day running of ordinary workplace disciplinary cases, no legal representation is allowed. I suppose that then poses us the question, who is allowed? And legislation does specify that an employee is permitted to bring a colleague with them or a trade union official. So the advice again would be that for you as an employer is to have that clearly stated in your staff handbook, in your disciplinary procedure. You must have a disciplinary procedure and just have a robust policy there. And again, my advice is if somebody does ask to bring somebody, be open to it, look like you're accommodating that request. And just again to refer back to Bright Contracts, we have a full disciplinary procedure there that's ready to go. Just press print if you need it, and that includes those requirements as well. But to move on to our next case, because I know, Nicola, you were looking at a really interesting case that's really topical and has been in the news a lot of late.
Yeah, so Laura, the case that I was looking at is Louth County Council versus Mary Clark. So this one deals with the issue of compulsory retirement ages. So the background to this case was that Mary started work in 2001 as a clerical officer with the council. On turning 65, Mary's employment was to end based on the retirement date stated in her employment contract. Mary, however, didn't want to retire yet. She wanted to keep working, and so she approached management to let them know what her intentions were. So a point to note here was that there were other employees hired later on the same grade as Mary, but who had a later retirement age that was based on a change in company policy. Mary's request was refused, and so she took her case to the WRC. At this WRC hearing, Mary submitted she was in good health and she was still very capable of completing her job. She also argued it was the responsibility of the council to determine whether she was capable of undertaking the functions for which she was employed to do. And Mary argued that the council had failed to do this.
Apologies, but the council weren't agreeing with this at all, and they claimed that extending Mary's employment beyond 65 would negatively impact on workforce planning and financial management, factors that they believed objectively justified the retirement age.
But WRC weren't having any of this, and so they rejected the argument. They found that the council had failed to objectively justify the retirement age, and that the justifications offered by them were neither appropriate nor necessary. And they then awarded Mary €13,000 in compensation for loss of earnings.
So the council then, they went back and they appealed this decision, denying that any discrimination had occurred.
Yeah, so they went to the Labour Court, but again now the Labour Court rejected the appeal. They concluded that the council had relied on a retirement age that existed at the time Mary started work, but which had subsequently been changed for the same grade of workers based solely on the date on which they had started employment. It found that the council failed to set out grounds that objectively justified the selection of the age of 65 as the retirement age for that grade of worker. The Labour Court stated the council's reliance on workforce planning and financial management was not justified by any legitimate aim. In upholding Mary's claim and dismissing the council's appeal, the Labour Court increased the compensation awarded to Mary from €13,000 to €20,000. So a very happy day for Mary.
Mary did well,
and
didn't
not
she?
so much for the county council.
Absolutely not.
So, like, currently there's no general compulsory retirement age in Ireland, but just to know that the mandatory retirement age now for most public servants is set at 70.
Yeah, that was only brought in last year,
recently,
wasn't it?
the Public Service Superannuation Age Retirement Act that you can see listed there.
So I suppose the case does demonstrate that the increase in the retirement age for the public sector, or most of the public sector, makes it difficult to justify a retirement age any lower than that in the private sector. But employers, when employers are setting their contractual retirement age, you just have to be sure that you're putting in objective reasons why you can justify such a retirement age. And it's important to remember that a clear, consistent approach is needed. And actually, one of the things that employers might consider is last year, because this whole issue of retirement has been so topical of late as well. Last year, the WRC released a practice guide, a code of practice exactly on older workers, or workers, working older, and it deals with how you should, approaches how you should deal with retirement in your workplace. And I think in this case, with Mary, she was contacting her employer about when she wanted to retire, where really the employer should be contacting an employee
proactively be managing
6 months to 12 months out in advance of that. So that's all set out in the code of practice, and it's something that if you have employees in your workplace around that age approaching retirement, you might familiarize yourself with that code of practice.
Yeah, and definitely there's many learnings from this case. So on the flip side then, Laura, there may be cases where an employer is open to allowing employees remain working beyond their contractual retirement age. And in this instance then, they can retire the employee and then just re-employ them on a fixed term basis, while again being able to objectively justify the reasoning for doing this. And the Employment Equality Act specifically provides that it does not constitute any type of age discrimination to offer an employee over the compulsory retirement age a fixed term contract. So to wrap up on this then, Mary's case and the points we have discussed here should be something you consider and manage carefully if your company has a compulsory retirement age in place.
Perfect.
And again, go back to Bright Contracts. So as you can see, Bright Contracts enables employers to state the retirement age they choose to apply, while the handbook then lets you objectively justify your reasoning for doing this. And this can then be explained to new employees, and if there's any confusion or any ambiguity around this, then they can be addressed and ironed out at that stage.
Yeah, so it's a really nice robust feature that we added to amend it as well.
Yeah.
Okay, so that brings us to an end of our side of the presentation. I hope you found it useful and informative. I do see that there's some questions coming in. I'm just going to open them. So whilst I open them, I've left this screen up for you. We've mentioned Bright Contracts and Connect throughout the webinar, so there's just a little bit more information on both of those products there for you. So bear with us now. We're just opening up our Q&As, and we can try and get to as many as we can in the next 10, 15 minutes or so. So apologies if we don't get to every question. Okay, I just see a question. I think that question, does an employer pay parental leave? I think we answered that throughout. I think that one might have come in before we got to that. Is parental leave 18 weeks, now 22 weeks capped? So it's 18 weeks at the moment, going up to 22.
From the 1st of September, and it'll go up to 26 weeks then in 2020. Yeah.
And sorry, we're just trying to read through them. Some of them are. We operate a farm and have a few employees. Would your contracts be suitable for this employment? Yes, absolutely. We have a number of farms and agricultural businesses that use it.
And through the Bright Contracts package, you're able to tailor the information in the handbook as well to make it more specific to your company. And there's some free text boxes in the contract template that you can go in and edit as well. So you can tailor it more to your own specific needs based on whatever policies or anything that you follow.
Which staff comes under craftsperson in construction? Would a machine driver be included in this? I think a machine driver would definitely be, if they're in the construction industry, would definitely be fall under the SEO. I have to double check that grid again to see exactly where they would be, but they would definitely be falling under the SEO. Sorry, okay, just another one. How can I write a contract for seasonal staff who come on board for summer, then remain as weekend staff throughout the winter? Yeah, you've probably two options, because Bright Contracts will allow you to do as many contracts as you like. So you might want to do a contract for the summer and then reissue a new contract come the autumn when they go back to college, just making sure that you honour their start date. Or you could just issue the initial contract and then add an amendment to it, give a letter. But because, again, it's so easy in the contracts, you could easily do that.
There's a question there about how do you calculate pro-rata parental leave for a part-time employee if their hours of employment have varied over a 12-year period? So I suppose you're looking at their current working arrangement and what hours they're doing. If they want to take parental leave, you'd be basing it off what their current arrangement is and you'd be pro-rating it down to that. Sometimes, if it's easier, you might want to even go down so far, break it into the number of hours that the parental leave falls in as well, and you'd be able to calculate them. And you just have to keep a record, keep kind of running total of whatever their balance is at the end of one parental leave period, so that when you're calculating again for the start of the next parental leave period, you'll know what their remaining entitlement is, and you just have to kind of carefully calculate what parental leave they're entitled to.
They have remaining.
They have remaining, yeah.
If an employee takes a sick day and it is in their contract that they don't get paid for sick days, can they request to use a day's holiday for that sick day? They can if they want to. As a management issue, you might want to just make a note that they did if sick leave was becoming an issue and you wanted to track it. But there's nothing to stop them.
No,
if you permitted it.
Very nice way to use some of your annual leave.
Yeah, exactly. Can employers still pay trainees a training wage? Well, I suppose that depends on the industry. I suppose in different, like we saw in the electrical, there is different rates for SEOs. But if your employee, I don't know, if they're on a specific scheme, then there may be a training wage associated. But if you're just employing somebody yourself and calling them a trainee, then they would have to really be, they'd have to be on the minimum wage and relevant to their age.
Yeah. Someone's asking about Bright Contracts there and what is the pricing structure. So Bright Contracts is €149 plus VAT for the full year. So it doesn't follow the tax year. So say if you purchase Bright Contracts now and you use it from September, you'll have 12 months the following September to use it. So it doesn't go with the tax year. So it's €149 now plus VAT, and you get the full contract, the handbook, free telephone and email support as well with the Bright Contracts package.
Absolutely.
I might just say, Laura, I might just say, if you want to as well, there is an online trial version. If somebody wanted to download the software and have a play around with it and actually just see how easy it is to use, or we also do a short demo on it as well. And if you wanted to contact us, we could set you up on the demo just to watch the live demonstration of how to actually use the software.
Absolutely.
Yeah.
Just a question coming in there, re the electrician's SEO, and you're dead right, Sandra. You say that the association has said that the sick leave pension entitlements are not in force yet. You are right, there is a judicial review and it's just kind of on hold at the moment, and the judicial review is in relation to pension, sick pay and debt in service. So the minimum wage rates that we put up on the screen, they will apply, but the pension, sick pay and debt is just on hold at the minute, and it could be a case that it is backdated to September 19 when it is resolved, but it is specifically relating to new entrants into that. So that's just something that we're kind of keeping an eye on at the moment, I suppose, Sandra. And the next one there, to be GDPR compliant, so let me just scroll in. How long do you keep employees' past and present records? Is that the same? Sorry, I'm just going to see, is that the same question? So each piece of employment legislation is going to specify different time frames. So we talked about parental leave being 12 years, and your general employee terms and conditions. The suggestion is 1 year for your employees' contracts, or 1 year after they leave employment. And that generally ties in with the option that an employee might bring an unfair dismissal claim against you within a year. But again, you might have to hold on to different information in relation to pension
information.
Yeah. So it's all dependent on the specific information.
What exactly you want to know.
I think we do, Lorraine, I think we do have some guidance on that on the Bright Contracts website, so we may just link that up after as well.
Yeah.
Sorry, just scrolling down to get in terms of employment. Is terms of employment okay for construction workers rather than contracts and handbooks? Well, the term of employment and a contract are kind of used interchangeably, I suppose.
Yeah, I'd say they nearly refer to the same.
One of the same thing. Yeah. So once you're ticking off all those terms, the terms that must be in it, it's generally okay. The handbook is separate, and the handbook tends to.
It's much more detailed.
Yeah, it contains policies and procedures, your approach, how your company deals with certain information or certain topics. So it's advisable to have that as a separate. Sorry, there's a row on there. If an employee is working on an 8-week contract, should they be marked as a leaver and rejoiner if starting another 8-week contract after a couple of weeks? And this is an interesting point, and this is something that the Employment Act miscellaneous provisions brought in, that actually employee who is working on a series of fixed term contracts where there is that small gap in between, they are actually considered under the new act that it's continuous employment, so they will have continuous employment over that period.
So if you have staff for a few years without a contract, what start date should you use? So you should use whatever their original hire date is. So by contracts, there is a spacing on that where you could put in like today's date is when you're generating the contract, but what their original hire date is, because that's what their service is calculated from. They should keep their original start date with the employer, and there is spacing on the contract to put that in.
Yeah, and then the next one, how long do you need to be in an organisation to be entitled to parental leave? So we mentioned that you generally have to be in a company 1 year. However, there is an exception that if your child is very close to that cut-off point of 12,
which is now 12,
there's a reduction to 3 months. But again, I think there'll be discretion on the employer.
If your employer is happy to support you taking the parental leave, I'm sure it wouldn't be a problem then.
Can you switch from Thesaurus to Bright Contracts? Bright Contracts is a standalone product. It's an additional product. It doesn't deal with payroll, so please don't move from Thesaurus because Bright Contracts is not going to do your payroll for you.
No.
But they do speak to each other. So if you were doing your payroll on Thesaurus and you wanted to create your contracts in Bright Contracts, you can. There's an import where you can bring over your employees' basic information.
Upload all your information from Thesaurus into Bright Contracts.
Is it mandatory to insert a retirement age in every contract? No. There's no mandatory retirement age, so you don't have to. But if you don't have a retirement age, it can be very difficult to retire an employee. When are they going to finish work? Are they going to just keep working? And if that's what you want, that's perfect.
But sometimes your own individual company pension scheme as well, they might specify whatever age their retirement or their pension kicks in at. So sometimes you might want to align your contract even to whatever your company pension policy is as well. So it could be worth looking into if that's something that you want to follow. On the Bright Contracts package, you don't have to put in a retirement age if you don't want to. You can leave that field blank.
Can a self-employed person apply for parental leave payment? Well, we've no parental leave payment at the moment, so no, you can't at the moment. We'll wait to see what the legislation comes in. If we expect it in November, so we'll see what the details of that.
There'll be communications, I'm sure, from the department around that side as well.
The Bright Pay contracts, is that the one that includes the holiday planner? No, that would be the Connect IFA. So Connect has the holiday planner, and where you can request.
And Connect is part of Bright Pay and Thesaurus, the payroll package.
Yeah, so Connect is the add-on to the payroll. It's a great way in terms of backup, particularly now in the PAYE modernization era, keep your backups safe and secure, but it also has that kind of HR functionality as well, like the annual leave, which is really fantastic. The contracts is much more the employment legislation just to get your contract sorted.
Yeah.
Again, sorry, if a contract is issued in 2019, the only change would be a change in minimum wage rate. Is it necessary? Okay, so I'll read that again just to be clear. If a contract is issued in 2019 and the only change is a minimum wage change, do you have to do up a new contract? No, certainly not. Like any statutory changes are going to
they're automatically going to apply to that individual. So
you may want to again issue a letter or an appendix to your contract just to update it.
Advising of the new rate.
And then it's probably best practice every so often to review your contracts and make sure they're up to date. Otherwise, you're going to be in that situation that Mary was in, where she had a much older contract than her peers and the newer staff.
And that kind of feeds on to the next question. Should you update employment contracts on a yearly basis? No, there's no need to that. Once you've issued your employee with their employment contract at the point of hire, you wouldn't have to go and issue new employment new employment contracts every year. Again, if there is a big change, you could do an amendment to the contract and give them a letter advising it. But again, if somebody got a contract like 10, 15 years ago, you might want to just review the current contract, and maybe through the package, you could actually issue them with a brand new contract.
Because it's so quick.
Just that it's so quick and easy to do.
And then everything's up to date.
It's more relevant, yeah.
Sorry, just one thing that we missed in relation to sick leave. Now, I know we didn't cover sick leave, but it's in relation to sick leave and sick pay. In our experience, do small businesses cover the first 6 days of sick leave before the social welfare acts kick in? Sorry, the social welfare pay kicks in. Oh, it's a hard one to say, Aoife, and it really differs from company to company. I find that where employers can, they try and pay some form of sick pay, and a lot of small employers might just pay it for 2 weeks. So it's up to the employer, and I said even a small amount can be helpful. And then you see different things that employers might only pay the 2 weeks if they decide on 2 weeks, with after a certain amount of service, certainly not in probation, and then it might only kick it in after 1 year's service. And some people then specified that the leave has to be certified, so if it's uncertified, they don't. So it's really a company decision, but there tends to be companies that are genuine, want to help people when they're sick, and if they can, every little bit, even if it's a little bit, it's a positive step. And it goes back to all that attracting staff that we talked about earlier.
I'm sure the employee would appreciate any payment that they can get while they are out on sick leave. Should a handbook be given to each employee, or can it be left in a place accessible to all staff? We definitely recommend maybe leaving it in a place that's accessible to all staff. The handbook can be quite detailed. Like if you include all of the policies, it could go up to 50, 60 pages long. So it's not something you want to be printing out and giving to every employee. So what you can do is you can leave it in a common area, maybe like a canteen, where people have access to read it. And if you want confirmation that they have read it, you could even get them to sign a document to show that they've actually read and understand all the policies within the handbook. But you don't necessarily, unless like you can.
Or better still, you can put it up on Connect. If you're using Connect, and
so you can export it as PDF from the website, and then you can send it to them through Connect, and then they have 24-hour access to the handbook for any questions or anything that they wanted to check.
Do you have to buy a Bright Contracts package every year? Yes, it's a 12-month rolling license, unlike the payroll, which is with the tax year. So it is just, if you were to purchase it now in September, it'll be next September that it will be due.
Is maternity top up at employer's discretion? Yes. So you get the statutory benefit, which is €245 a week. And if you want to top up an employee's salary, that's totally your decision if you wanted to do that.
I just did. I think there's one on banded hours. I'm surprised. Oh, sorry, I'm after scrolling down. I hope we haven't lost it. Where did that go? Bear with me now. There's a question on banded hours. Somebody with 22. Sorry, Bernie, I have your question here again. Sorry. Some employees have a contract for 22 hours, but because of the type of business, some weeks they'll work more, and some weeks they'll work less. Is that a case for banded hours? Well, it depends on how many more hours they work over the 22 and how less. What's the variety?
And the review period is 12 months.
Yeah.
So you'd be looking at the number of hours they do over a 12-month period.
But it's really like if this is fine, Bernie, this situation is fine, and this is what happens in organisations because of seasonal, highs and lows. So unless an employee comes to you, then you'd have to requesting it. Then it might be something that you'd have to look at. But it's perfectly fine, and as Nicola said in the presentation, there'd be no action required. If a contract for 22 hours, it should be fine.
Yeah.
Okay. We're coming close. We're gone over the 12, but I think we're coming close to the end. Is bride pay a more flexible package than SOAR as well? Nicola and I aren't going to answer that. We're going to put you, Angela, in touch with some of our excellent salespeople who'll be able to go through the ins and outs on that one for you, if you don't mind, Angela. Company takes, I don't know, this is an odd question, it's just the last question. Company takeover gives a new contract. Is there a time limit to make changes? It's difficult to understand that question, Margaret. We might come back to you on that one if that's okay.
Well, we can follow up with you directly and just get more specifics, I suppose, before we know exactly what we have to answer.
Perfect. I think we've kind of come to an end of the questions. Thank you all very much for attending today. I hope you found it useful. We do have a short questionnaire at the end. We love hearing your feedback, so it'd be great. And if you would like more information on bride contracts or SOARs, or the difference between bride pay and SOARs, let us know. We'll be in touch with you. And also, just to let you know, we do have a number of other webinars coming up shortly in the next week or so. So if you're interested in them, be sure to sign up as well. So that's us. We'll say goodbye and thank you very much.
Thank you. Bye.